Finally, we take on this concept of commercial impracticability. Impracticability is a legal term. It doesn't mean impossible, but it means almost impossible, meaning something cannot be completed without extraordinary events occurring. So the perfect tender rule does not apply when some unforeseen occurrence has occurred to make performance impracticable. When a contingency has occurred that was not contemplated when the parties reached their agreement. The UCC will excuse the seller's performance when a contract becomes commercially impracticable, when the delivery or the non-delivery of goods has been made impracticable by the occurrence of an unanticipated event, and the unanticipated event directly affects a basic assumption of the contract. If I am shipping goods to you in February of 2020, and we reach an agreement that I'm going to ship the goods in February of 2020 for arrival at your place of business in April of 2020, and in the meantime the world shuts down, the country shuts down because of the pandemic, then it becomes not impossible. I could pay someone somewhere to deliver those goods, but it's commercially impracticable. It's not something that we could easily or readily accomplish. Now, it is important that the event must have been unforeseen by either party at the time of contracting, because commercial impracticability is a narrow doctrine, meaning only certain events will qualify as commercial impracticability. Because what you're doing when you allow for an excuse based on commercial impracticability, you are saying, yes, I breached the contract, but I had a really good reason. So in cases of commercial impracticability, delay in delivery may not be a breach of the contract because there was this unforeseen occurrence. Think again of the supply chain disruption that occurred because of the pandemic. If there are literally no ships transporting goods at the time, then my delivery may well be impracticable. Perfect tender rule does not apply in cases of impracticability. And again, must have been unforeseen by either party at the time of contract. And if there is commercial impracticability, the failure to achieve the perfect tender rule may not be a breach of contract. What about destruction of the goods before risk of loss is passed? That may excuse the parties from performance. The parties are excused from performance when some unexpected event occurs that is not the fault of either party, and it destroys identified goods before the risk of loss has passed to the buyer. If the goods have been destroyed through some event that was no fault of mine as the seller, and the goods that were destroyed had already been identified, then I may be excused from performance under the contract because of the doctrine of impossibility. The goods that I was obligated to deliver no longer exist. Therefore, I am no longer obligated to deliver them. Again, this is an exception to the perfect tender rule. The UCC also governs what's called assurance and cooperation. If a party has a reasonable belief that the other party is not going to perform, that party may demand what's called an assurance of performance, meaning you must give me some assurance that you are going to ship the goods, that the goods are going to be shipped to me at the time specified in the contract. Or if I believe that you're suffering financial difficulties, I can demand assurance that you are going to pay for the goods if I'm the seller. Furthermore, if performance requires the cooperation of the other party, a failure to cooperate can relieve the obligation to perform. There is in every contract an understanding that the parties will cooperate. And if you fail to cooperate, it can relieve the obligation to perform. Now, in any transaction, the basic obligation of the buyer is to accept and pay for conforming goods. Once the buyer has accepted the goods, the buyer must pay for them in accordance with the contract. And in the absence of any agreement to the contrary, the UCC provides that the buyer must make full payment at the time and place that it receives the goods. Now, this is the legal definition of goods, meaning it may be different than what an actual receipt. If the parties agree on credit for the payment, interest typically begins accruing 30 days after shipment. It's very standard in the industry that one's obligation to pay does not occur until 30 days after receipt of the goods. However, if you delay more than that, then you will owe interest on the amount in excess of what the contract amount was. Now, there are rules regarding acceptance and rejection. The buyer has the right before delivery or acceptance to inspect the goods in a reasonable manner. And a buyer's right to inspect the goods is absolute, meaning a buyer has a right to inspect goods. And acceptance of any part of the goods constitutes acceptance of the whole. The buyer has a right to inspect the goods. The buyer has a reasonable time period to inspect the goods. Remember, this is one of the expectations of a buyer, that it can inspect the goods before having to pay for them. After inspection, the buyer may communicate to the seller, yes, I accept the goods. Or it may do nothing and thus be presumed to have accepted goods. Or it must notify the seller that it is rejecting the goods or part of the goods. If the goods are conforming, the buyer has the duty to accept them. The buyer has an obligation to affirmatively notify the seller of a rejection in a timely manner so that the seller has an opportunity to cure. So if the buyer rejects the goods, it must notify the seller promptly, and it must explain why it is rejecting the goods so that the seller can then exercise its right to cure. Acceptance of the goods exists when the buyer agrees to do so, makes express acceptance, or when the buyer fails to make an effective rejection, or acts in a manner consistent with ownership. It stores the goods in its own warehouse, for instance, or it arranges to sell the goods. That will constitute acceptance of the goods. If the goods are partially conforming and partially non-conforming, a buyer can accept only those goods that conform to the contract and reject the rest. The buyer may pay by any means specified by the parties, or if it's not specified in the contract, by any reasonable means. And again, when the sale is on credit, the buyer must pay according to the terms of the contract and not when the goods are received. There are special rules for installment contracts. An installment contract is one which requires or authorizes delivery in 2 or more deliveries. The UCC provides for delivery and billing to be done in 2 or more separate lots through the use of an installment contract. The law says the default rule is that each lot must be accepted separately and paid for separately, meaning if you have an installment contract calling for the delivery of certain goods over the space of a year in monthly installments, the obligation to pay comes every month. When the goods are accepted, there is an obligation to pay for those goods. A buyer or lessee can reject an installment only if a nonconformity substantially impairs the value of the installment and cannot be cured. And a buyer can reject the entire contract, the entire installment agreement, only when the nonconformity will substantially impair the value of the entire contract and not simply the installment that is relevant here. So in conclusion, what did we learn today? Obligations of good faith and commercial reasonableness underlie every sales and lease contract under the UCC. The basic obligation of the seller is to transfer and deliver conforming goods. The basic obligation of the buyer is to accept and pay for the conforming goods. That's all for this one. I look forward to seeing you in the next lecture.